Good to see everyone. Thanks for coming. We're a little light today. A little bit late. I hope that wasn't the topic because so this topic, just so everyone knows, this topic was requested by Marcia Travis, and she's over at Four Seasons. And so it's an unusual topic because as all of you know, we don't represent real estate agents, we don't represent real estate brokerages. We don't do transactional real estate work. So really at first blush, it really seems tangential to what we all talk about every first Friday, but it's not. And here's why. It's a little bit scary, but there are implications in terms of the disclosure in this act that we really have to think about. So thank you so much, Marcia, for sending that in. And we have to do dog of the day, I think, first. Just a little housekeeping business. Dog of the day, and that is Betty, and Betty is owned by Elaine Wargamary. Elaine has been in the industry forever. She is Elaine Murray Expert Consultant Services now, but for many decades she owned E.W. Murray Management Company, and then thereafter Regency Management. But it's really nice to see Betty out there, and thanks Elaine for sending the picture in. So let's go on to our usual more housekeeping is, these seminars are for informational purposes only. They do not and cannot form an attorney-client relationship. This is not legal advice. It's purely for discussion, educational purposes. And if you need an attorney, you can reach out to us and sign us up for your association, or you can refer to your own association's attorney or hire a new attorney. And nothing we will talk about today will be kept in confidence, so please don't say anything that would be confidential. Do we have any realtors on the line today? Any realtors? There we go. There's Marcia. Anybody else? Oh, hey, Maddie, we're following up on your Senator Turner question too, by the way. We'll get back to you on that. But thanks everyone for attending again. So what are we doing first? So how did this happen? Why did this happen? Why are suddenly things changing in the real estate world? Why are the real estate brokers suddenly subject to this new legislation that became effective August 1st? What happened was there was a class action lawsuit, and that is the Burnett versus National Association of Realtors. So let's take a step back because there are many of us who probably aren't familiar with this. The realtors will be, and if I say anything wrong, please, the realtors jump in the chat and scream at me in the chat. So you can type in all capital letters. That's not true. Fran McGovern, stop saying that. So real estate brokers, real estate agents, and salespeople are not realtors unless they are, right? Unless they are, right? So all realtors are licensed real estate professionals, but that doesn't mean all the licensed real estate professionals are realtors, meaning they're not necessarily members of the National Association of Realtors. The National Association of Realtors is a trade organization nationwide, and in fact, it's bigger than nationwide because I think it covers Puerto Rico and some other areas as well. It has a national trade organization that does training, networking, education, ethics, compliance, etc., for their real estate broker members. Okay, so it's a trade organization that is, I guess you could call it international. But they have state chapters, local chapters, etc., that are usually populated by boards that are made up of local real estate professionals, okay, that help administer them. They also form and administer typically certain multiple listing service websites on the internet. Okay, so that's a big part of the practice as well. And historically, the National Association of Realtors had guidelines, rules, and regulations as to how their members can conduct business, how they see the ethics of that business being conducted, and they linked those rules and regulations and guidelines to a real estate professional's ability to post things on the multiple listing services. Okay, so that's how we got to the Burnett case, because you had a national organization that also had local chapters, but more or less specified uniform guidelines, more or less uniform guidelines throughout the United States and their chapters in terms of how business is conducted. What happened was the Burnett people, and there were a number of plaintiffs, the putative class representatives, filed a lawsuit against the National Association of Realtors on behalf of sellers of real estate. On behalf of sellers of real estate, I'm going to take my glasses off because I can't read and see at the same time. I need trifocals. So the National Association of Realtors had these rules and regulations, and the sellers filed a lawsuit claiming a number of things. First of all, they said the National Association of Realtors, there are various subchapters, and the various, we'll say, they named the large corporate franchisors in the real estate business, conspired to do a couple things. Their claim was they conspired to inflate commission rates. They conspired to compel sellers to pay buyers agent fees, right? So everyone who's done real estate in New Jersey in this kind of world forever knows, generally speaking, you'll see that a realtor will say, hey, we will split the commission. And usually it's a straight up split, but sometimes there's other arrangements. And then the third claim was that more or less they steer prospective purchasers to properties where the commission split may be more lucrative for the realtors. Okay, so that was the claims of the plaintiffs. They had an expert that, believe it or not, testified. The expert in the case testified for the plaintiffs, saying that if you compare the general system through the National Association of Realtors and you compare that fee splitting arrangement that the National Association of Realtors enforced with, believe it or not, the way transactions are in Australia, and he had lots of research on this, he could possibly demonstrate that the fee structure and the fee sharing structure led to inflated expenses for the sellers of homes, right? And also led to the sellers of homes being forced to pay their buyers' realtors' commission. The class was certified, for those of you who are familiar with class actions lawsuits. So in a class action lawsuit, you get a group of people that, and I'm not going to go through all the requirements for establishing a class, but basically if you're similarly situated and you have similar claims and damages. So in this case, the court certified the class out of Missouri, and ultimately it went to trial. The plaintiffs won against the realtors, National Association of Realtors, and of course, there was notices filed that the cases were going to be appealed, right? So just because you guys know this, anyone who's been involved in litigation, just because you win a lawsuit doesn't mean the case is over and someone's going to give you a big fat check on Monday morning. No, when the parties file appeals, that does a couple things. One, it can delay the case for years, if not decades. Two, it puts your claims at risk. It puts your win at risk. So often, large cases in particular will settle after trial, even though one party has been very successful in the case, because they want to avoid the risk and delay associated with the appellate process, right? And this was a very large case involving a lot of people in the class. I don't know, I don't have off the top of my head exactly how many people were in the class, but it was a very large class. So what happened? After the trial, the plaintiffs were successful, and they entered into a settlement agreement. They entered into a settlement agreement, which was about 145 pages long, including exhibits, right? And the settlement agreement provided for a number of things. It provided for a $418 million payout to settle the case. That's a lot of money, right? $418 million. And then it also provided, and goes page after page after page, of how the National Association of Realtors will change their practices and procedures in terms of compelling sellers to fee share to get on the MLS, and many other topics that we'll talk about in a second. So that's the background of this case. What the Burnett expert in the Burnett case testified to, more or less, and this is important for realtors, is not so important for associations, is that it was his opinion that if the structure was changed, if the fee structure was changed, that it would be very unlikely that people in the future would use buyers' agents, right? That was the testimony in the case, and that's basically how he testified that things have worked out in Australia. So that basically, the theory is, I guess, if the fee structure is changed, people won't go out and hire buyers agents, but eventually, once the practice evolves into the new paradigm, that people will just be more or less dealing with sellers agents, right? That's the theory. I don't know if it's going to work out that way, but that's the theory. So then we get to our new law that we're talking about today, which was the Senate S 3192 and Assembly 4454, the Real Estate Consumer Protection Enhancement Act. Some of these titles of this legislation, right, cannot exactly give you the full information on the legislation, but it was effective August 1st, and Governor Murphy had signed it in July. As I said in the agenda here, real estate agents have a lot to think about. One thing that's interesting to me, and something that I got jammed up with back when I used to think I was a real estate speculator, which I'm not, but both the sellers and the buyer's agent are required to present all offers, regardless of the fact that it may be under contract. That's a big change, at least from my perspective, because when I was trying to buy houses in the past, people would say, it's under contract, I can't talk to you. It's under contract, I don't want to hear it. That's at least what my personal experience was. I don't know if that was right or wrong in the industry, because again, I'm not a realtor and I don't represent realtors. But so that was a big change. There's a whole bunch of other change that goes into the process, and disclosure is the biggest thing, right? So the disclosure to both the selling homeowner and to the prospective purchaser, how the fee structure is going to work in terms of compensating the seller's agent, how the compensation will work as to the buyer's agent. As far as I can tell, it prohibits advertising on the MLS fee splits with a buyer's agent, right? And there's all types of detail on this, and I think most of the national realtors chains have modified their forms already in terms of listing agreements and so forth. It prohibits, for example, saying that the buyer's agent services are free if they're not, right? So historically, there were some people apparently that were saying, hey, you don't have to pay me anything, buyer, which there is truth in that, right? But that doesn't mean it's free, because the seller in the past, under the past paradigm, was actually doing a fee split, and the buyer's agent would be getting paid at closing. And people saw these on the closing statements. So it wasn't like it was necessarily hidden, but it seems like the legislature considered that to be not as transparent as it should be. The biggest issue, like I said, disclosure is huge. So the real estate agent has to disclose to all parties any material information that has to do with the property. Now I'm going to do something that you will hate, but it's going to be really, really boring, but it's really, really important for us, and you'll see why in a second. So the biggest issue that comes up is disclosure under this act. And I'm going to read the actual statutory boring provision so that you can see how big this is from the realtor's perspective, and in my opinion, from the association's perspective. So this is the link to the association. So it defines material information with respect to a real property transaction. So material information means the existence or non-existence of information to which a reasonable person would attach importance in deciding whether or how to proceed with a transaction, right? Important. Or this is where it gets weird for the agents in the room, that the agent knows or has reason to know that the recipient of the information regards or is likely to regard as important in deciding whether or how to proceed, although a reasonable person would not so regard it. What does that mean, right? That's really hard language. What does that mean? What that means basically is even though your average citizen on the street might think something is not that important, as a real estate agent, broker, salesperson, or what have you, you have special knowledge. And if your insight and training would suggest to you that that would be important in a real estate transaction, you must disclose it, right? Even though you're reasonable. I love that, Charlie. Even though, even though a reasonable person on the street might not find it important themselves, right? It basically puts the onus on a realtor or real estate professional to, in my opinion, decide what is important. And if I was going to be in a position of a realtor, I would err on the side of more information is better, right? More information is better because you don't want your hiney sued because there was information out there and you didn't provide it. Okay, so that's one provision. That's the definition of material information. The next section. The buyers and sellers agents, as well as others, brokers, etc., have an obligation to disclose all existing material information known by a real estate broker salesperson, or real estate salesperson acting on behalf of the brokerage firm, or which a reasonable effort to ascertain the information would have revealed to their principal, and when appropriate, to any other party to the transaction concerning the condition of the property that is for sale. I know that's a mouthful. I know I put you to sleep when I was reading that. But what does your antenna go up when we talk about that? I'll read it briefly again. Or which a reasonable effort to ascertain the information would have revealed to the principal, and when appropriate to any other party to the transaction. Your antenna should go up because we've talked about this stuff a lot, and your antenna should go up with one, the new structural inspection requirements, right? Number two, what about the reserve funding requirements that went along with the structural act? The question that comes up, and I don't know the answer today, but why this is so critically important for associations is if you're a realtor in the position of selling a condominium association unit, especially, do you have a duty, in the case that qualifies for the structural inspections, do you have a duty to go to management and say, I need a copy of the structural inspection report that says this association is compliant with the structural act, right? And if so, am I obligated to give that to my potential purchaser? I think the answer is probably yes. I think the answer is probably yes. The second question now is to reserve funding. Now it says, as to the condition concerning the physical condition of the property. So someone might argue, Fran, the realtors don't have to worry about the reserve funding part because the funding doesn't really have to do with the physical condition of the property. The counter argument to that would be something different. It would say, wait a second. The statute requires you to get reserve studies. It's arguable over whether or not you are required to give me the budget and so forth. I think you would be anyway. But I need you to give me the reserve study that shows me the remaining useful lives of all the common elements in the property. And especially with a condo association, many people would say, well, wait a second, Fran. When they say property, they just mean unit, the condition of the unit. It doesn't say the condition of the unit, though. And especially in a condo association, the unit is inseparable from the interest in the common elements. So I think there's a very, very good argument that this statute, even though it may not have fully realized it, but this statute puts the onus on the realtors to provide very broad disclosure, in my opinion, right? And when we read this with the statutory amendments that address the structural and reserve funding components, it really will, I believe, really impact associations. The other thing is when it says, which would reveal to the principal when appropriate, and to any other party to the transaction. Any other party to the transaction. What does that mean? Does that mean that the realtor is only obligated under this law to give the information to the buyer and seller? Or does that mean any other party to the transaction? Does that include the mortgage companies? Does that include the homeowner's insurance company? I mean, I think a reasonable reading of that sure may suggest that that would be providing that kind of disclosure to both the mortgage company and the insurance company. And as we all know, how many associations do we know who are in full compliance with both the structural regs and the reserve funding regs? Okay, a lot of the people may not be, right? And if they are not, will that pump the brakes on your closings in terms of closing deals, right? Because will mortgage companies get that information, right? And it'll hit underwriting, and the underwriting people will say, oh, wait a second, this place has structural issues that have not been addressed. We have a report here that says that. Or this place has reserve funding issues that have not been addressed. We're not writing the mortgage, right? And the same goes for the insurance issue. I'm not trying to scare anyone, but this act, although when Marcia first suggested, I'm like, well, you know, it might be kind of tangential. Once I really got in and jumped into the act, which I don't think that was the original intention. The original intention was, I think, really to focus on the Bennett case and to focus on MLS and how MLS is run and the fee structures for real estate professionals. It really gets into disclosure. So not only disclosure of the real estate professional's fee structure, but also disclosure with respect to the property. The act goes on. The real estate professionals, I'm using shorthand here, have a duty to undertake a reasonable effort to obtain material information concerning the condition of every property for which the brokerage firm accepts an agency relationship or is retained to market as a transaction broker, and concerning the financial qualifications of every person for whom the brokerage firm submits an offer. So in terms of putting a burden on the brokers, again, the real estate professionals, that seems to mean that if you are an agent and you are representing a potential purchaser in an offer, it sure seems like it's saying you have to financially qualify that person. I don't know how much that means. You know, I mean, yeah, as you know, the realtors in the room, you know, a lot of people can just get a one-page fax from a bank that says, yeah, they're good for up to $450. Yeah, Marcia's saying that's new, not new. Thanks, Marcia. Yeah, that's not new. I just don't know how far they'll go with that, right? Financial qualifications for every person the brokerage firm submits. Again, historically, in my experience, that's been a very easy thing to come up with, as long as you can get from a mortgage that Fran McGovern is qualified for a mortgage of 550 grand. You know, my realtor would just give it to the potential salesperson, and that would qualify. I just don't know how far they'll go with that. And I'll just continue. And I know, Marcia, you said that this is already in the law. An offer to the brokerage firm's principal, provided that the broker salesperson, or salesperson at the brokerage firm who undertakes the reasonable efforts, and this is good, shall not be held liable to a standard of a licensed property inspector unless the broker salesperson, or salesperson is separately licensed as a property inspector. So gives the realtor a little bit of wiggle room, right? In terms of, you know, how much craziness burden is on the realtor in terms of inspecting the property. Unless you are also a licensed property inspector, it doesn't put as high a standard as a licensed property inspector upon the real estate agents, but especially things that are immediately visible, right, or very obvious, and especially things that a realtor, as a trained real estate professional, knows that somebody would find important. And as I said, for all of us in the association world, especially with respect to condos, that goes to structural studies and transition studies and reserve studies, right? So if you're a community and you have not gone through the transition process and had a settlement with the developer and you're reselling units, are the realtors working in your association obligated under this to get a copy of a pending transition report and present it to the buyer and seller? And that's going to be an issue with us association attorneys because we try to claim privilege oftentimes in those documents, litigation privilege, expert privilege, work product privilege, things like that. And various attorneys may be unwilling to give up transition materials when the case has not been settled yet. So I'm going to just go on and bore you a little bit more because the language about disclosure just goes on and on and on. And I'm just going to read a little bit more and you could scream at me, I guess, in the chat. A brokerage firm shall not be liable for information that is to be disclosed by a seller in a property condition disclosure statement that is provided under the law or otherwise by law, or that the brokerage firm requested the seller to provide and was not provided to the brokerage firm. However, the new edition says, provided a real estate broker salesperson, or real estate salesperson acting on behalf of the brokerage firm made reasonable efforts to ascertain all material information concerning the physical condition, including but not limited to making inquiries to the seller about any physical condition that may affect the property, and performing a visual inspection of the property to determine if there are any readily observable physical conditions affecting the property, and made disclosure of such information to the appropriate parties to the transaction as required by law. So it's written in here, it's got to be 3, 4, 5 times that they are really putting a disclosure onus on the real estate professionals. Again, this is my opinion. I'm not an expert in this field, but just based on the law itself. I haven't seen any decisions on that, on this type of stuff. I think you will see significant litigation coming out of this. I think you will see significant litigation coming out of this because you can imagine that if these duties, as Marcia noted, many of them are new, but some of them are not. But the new ones especially, someone has basis now to claim, well, wait a second, time out. The broker professional or the real estate professional had an obligation to tell me, fill in the blank, and they didn't do it. And the broker responds, or the salesperson responds, well, the seller didn't give me that information. And they say, well, that's nice. We don't care if the seller gave you the information or not. You, as a real estate professional, should have known that the association was required to have a structural inspection report or had a structural inspection report, and you didn't get it to me. And then I moved in and they did a special assessment for the structural repairs, and I had a $25,000 assessment. And now, real estate professional, you owe me $25,000. That's where I see these cases being a big risk for realtors, real estate professionals, brokerages, et cetera, right? Because it's not just rearranging the fee structure and the compensation arrangements for real estate professionals. Again, to me, it really raises the bar in terms of providing information and disclosure. Just going to keep going, and I'm almost done the reading part, and then I'll start talking again. So this is kind of the last part on this. A brokerage firm representing or working with the principal may not be charged with knowledge or notice of any facts known by the principal that are not actually known by the brokerage firm. Again, it goes on, provided a real estate broker salesperson, or real estate salesperson acting on behalf of the brokerage made a reasonable effort to ascertain all material information concerning the physical condition, including but not limited to making inquiries to the seller about any physical condition that may affect the property, and performing a visual inspection of the property to determine if there are any readily observable physical conditions affecting the property. So again, these additions, and these are new provisions I'm reading now, I think put a lot on realtors. I think they do. And I think they put a lot on associations in terms of how are association attorneys going to advise associations when the requests are made by real estate professionals. How much information is enough? how much information is too much, how much information is given, and will it create a claim by the selling unit owner that the association or the realtor blew their deal? You see what I'm saying? You didn't need to tell them the reserves weren't adequate. You didn't need to tell them that we were in a transition litigation with the developer because common elements are messed up, right? You didn't need to tell them that we had a structure report that says the parking deck is bad. So it's really, I think this statute is again, I've talked about new legislation in this vein a number of times, is very well intentioned. And as you know, I'm a huge proponent of transparency and disclosure. It just is going to have some implications that I think are going to take several years to work their way through the system, both on the real estate professional side, as well as the association professional side, and also, unfortunately, through the courts, right? Because when someone sees a $20,000 assessment for replacement of their deck or what have you on one of these, waterfront towers in Monmouth County, they are going to be looking for someone as a target if that has not been disclosed to them and the association had information or the realtor or the owner had information. So it's really challenging to know. Again, does that result, again, assume we have a situation where something is not disclosed, but it was determined to be material. Does the unit have a claim? Seems to be. Does the mortgage company have a claim? Possibly. Does the insurance company have a claim? Possibly. Can the insurance company drop coverage if it finds out after the fact? Probably, right? So this raises many issues. How may property values be impacted? Inability to secure insurance. Insurance is a very big thing right now. As you know, insurance has gone into the stratosphere, especially in states like Florida, but it hasn't been a happy scene in New Jersey in terms of associations, insurance policies, or homeowners insurance policy. It's going to very likely expose much more to brighter light associations that have not addressed the structural integrity law. It's going to shine a bright light on associations that have not gotten reserve funding studies, and the reserve funding studies, if they have gotten them, are not being properly funded, right? Because the realtors, I'm virtually certain that the realtors are going to be told by their brokerages, hey, get the information, right? Because we don't want the target on our back, right? So the realtors are going to be out there trying to do the right thing, but the association people on our side of the equation are going to have to decide what to put out there, if anything, how much is too much, and how do we deal with association homeowners who are trying to sell their unit and may claim that the association and or one side of the realtor equation hurt their deal or stop the deal. So who might be liable for what? Everyone hates this part, but who might be liable for what? People could raise claims against real estate agents. They could raise it against brokerages. They could raise it against associations if the association is not disclosing things. The association could raise claims against management companies, for example, if the various parties know that there are problems with the physical structures in associations and they are not disclosing it, not funding it, and not dealing with the structural and reserve funding laws. So I know I always seem like doom and gloom, Fran McGovern, and I hate to sound that way, but the way this statute is written, it's going to be, in my opinion, a fairly significant burden for associations and for realtors. I mean, so it's going to be interesting to see how it plays out from the disclosure standpoint. So my last bullet point there is regulations to be expected. Yes, just like Radburn, right? So this law provides for the state administrative structure to also issue regulations. So you'll remember Radburn was in 2017, I think, the act itself, but the regulation didn't come out for several years later. So same thing here. So this act, I think, is I don't think, I know the act authorizes administrative regulations to be adopted. So I think that you will see regulations coming out within the next couple of years. Now, I imagine the realtors will want to weigh in very much on these proposed regulations, and I expect associations will want to weigh in on them as well as consumer groups. But so the the law, as I said, it has a lot of implications for real estate professionals. It also has a lot of implications for associations. The interesting thing will be, will the real estate world, in terms of compensation, evolve like the experts in the Bennett case say they will? Will the so-called buyer's agent diminish and eventually go away? There are some realtors out there, I've been told, I don't know if this is 100% true, it's all hearsay, but there are some uh, realtors out there who are apparently telling potential buyers that they must enter into an exclusive buyer's agreement uh, to be a buyer's agent. That I don't believe is true under this act. Um, Although there are apparently people out there saying that's true. The way the act is written, it appears to me that if a buyer's agent wants to get paid, the buyer's agent has to have an agreement, a compensation agreement with the buyer. It doesn't have to be exclusive. There are all types of details on this, but has to have an agreement. However, nothing that I see in the act requires a buyer to have a buyer's agent, right? And there does seem to be some misconception out there in the field at the moment. So, Marcia noted, and we'll talk about in a second, um, about a potential buyer must sign a an agreement prior to entering a home. I'm not so sure about that, Marcia. I'm not so sure. That's not the way I'm interpreting the statute right now. And again, that's your bailiwick, so I will defer to your people to a degree, but I'm not so sure about that. The act is written a little differently. It's a little strange. I know there's a signage requirement for open houses and so forth, um, but it's going to be interesting to see how it works out on the buyer's agent side of things, because I've seen, I've run into a couple instances where buyers have refused to sign anything and they're still looking at houses. It's going to be a little bumpy, Marcia. I think you know that. Um, but but we'll see. Okay, so I'll jump into the chat. I know I'm kind of rambling, and I hope I didn't put anyone to sleep. Um, is this retroactive to sales done this year? Jeff, not to my knowledge. Most laws are not retroactive. There's a policy against that generally in the law. So the answer is I don't think so. Co-ops have proprietary leases, and the certificate holder only owns a proprietary lease, which allows him to live in the unit. The co-op owns the unit. So under this act, who has the duty to disclose? Is it the certificate holder or the co-op? That's a really good question, Bill. I would say that the realtor has an obligation, and probably the association probably does too. I don't want to answer that straight out, so don't rely 100% on that. But I think the realtor still has an obligation under this. I didn't look at it the perspective of tenants, but I do believe the act refers to tenants as well. I don't know if the intention there was to subsume co-op tenants of the proprietary lease, but I think when in doubt, I would say this act probably covers. But if you are a real estate professional, I think you should speak to your brokerage's legal team, or the legal team for the National Association of Realtors, because I imagine the local chapters of the National Association of Realtors are weighing in on this big time. There you go, Marcia. So realtor, right? So the realtor. So realtors, so people. Let's talk about as an example when we say realtor. My opinion is when you have somebody who is in a profession, I think you should also be encouraged and to participate actively in the industry organizations in that profession. So I think it's a good thing, notwithstanding the Bennett case. I think the professionals who are in the real estate business participate with realtors as realtors, the National Association of Realtors and local chapters. Generally speaking, you want professionals that are participating in their industry groups. So you'll see in the association world, I mean, an attorney who participates in the association world regularly, like myself, we're members of the Community Association Institute, right? Because this is what we do for our livings all day, every day. So it makes perfect sense for us to participate in the leading industry association. However, where the National Association of Realtors got jammed up was in basically compelling the fee structure, right? And compelling and linking the fee structure and the compensation structure to the access to the multiple listing service, right? So I'm in no way, I want to make sure I'm in no way knocking people who participate in the National Association of Realtors. In fact, I think it's a good thing for professionals in the field to participate in their industry trade organization. As a property manager, we can't give info only to the owners, no one else. As a property manager, we can't give info. Oh, we can give info only to the owners, no one else. Right. So there's some truth in that, Judy. You can't just send information all over the place. The issue there is, though, if an owner was selling and the realtor said, hey, I need this information, the seller will have to obtain it from the association, right? Just like they do with closing certificates, estoppel certificates, payoff statements, etc. So if a seller, if a homeowner was saying, hey, you can't give any of this information out to my realtor, the problem is going to be the deal's not going to happen, right? If the underwriters and the insurance people are requiring that information. Yeah, Marcia had noted that other provision that I read about the financial certification of a potential buyer was existing law. Jeff says, a mortgage company recently stated that the association having a $10,000 deductible for water damage and a $10,000 deductible for sewer claims is above the Fannie Mae and Freddie Mac limits. This is the first time I'm hearing of this. Have you ever heard? I have never heard that, Jeff. I have never heard that. I cannot imagine that is true because many of the associations we work with have at it more than a $10,000 deductible. So I have not seen anything like that. The buyer's agreement is mandatory now. Marcia and I might not see 100% eye to eye on that, which is okay. Which is okay. Seek your own counsel on that. Like I said, we don't represent homeowners. We don't represent buyers. We don't represent sellers. We don't represent real estate professionals. There is going to be a bunch of debate on that. So the odd thing, this is an odd thing, but this is easy for me to say as a lawyer. Part of the Bennett case was that the National Association, one of the claims more or less was the National Association of Realtors and their state associations, local associations refused to negotiate fees whatsoever, right? That was part of the claim, right? That it was basically an antitrust price fixing claim, right? The odd thing for me though is, and I have purchased over my career probably 2 or 3 homes. Being a lawyer, I have worked with realtors and they have worked together and worked with me to modify their fee structure. And that may be just because I'm a lawyer and I'm used to talking to people. But I have never had a realtor say to me, no, the law requires to mandate, this is the fee structure, this is the way it is, and that's the way it is. So I had not found that in my experience in life, but that was the claim in the Bennett case. And the expert on behalf of the plaintiffs demonstrated statistically, at least the court found it statistically reasonable, that even though the National Association of Realtors said that that's not true, and like I said, in my personal experience, I have found that that's not true. Statistically, he was able to establish that the rate structure set by the National Association of Realtors was abided by in virtually all cases. Not all cases, but in virtually all cases. There got to be some little wiggle room in terms of pocket listings and things like that that are exceptions backed out statistically. I won't get into the whole decision, but That was the plaintiff's claims. Like I said, I did not find that in my experience. I am having my tenant sign an agreement. Okay, I'm not sure, Judy, about that. Okay. Um, let's see. Bill says, I completed a New Jersey Associated Real Steel the standard form of seller's property condition disclosure statement form, which selling realtor insisted I complete, which she gave a copy to the prospective buyer. It contains 107 questions with 6 pages. Why would this existing form? So the existing form will still be used for sure, right? So that's still going to be used. And that has been used historically, right? So more or less, some of the forms have changed over the years, but the seller's disclosure, and go ahead and correct me if I'm wrong, Marcia, has been used for years and years, right? Which is a good thing, right? The weird part is, though, this statute extends the duty um, to the real estate professional to inquire and to gather things that the seller may not even be aware of. You see what I'm saying? A seller of a unit in a condo association might be like, what? What? Structural inspection law? What are you talking about? But many realtors will be aware of the structural inspection law, right? Many condo unit owners will be like, what are you talking about? Reserve study. Um, that's craziness. I'd never heard of such a thing. But a realtor who is experienced will know that reserve studies are quite common and they list the useful lives of the common elements. So it puts the onus, this law extends the onus, not just the disclosure statement, which the seller would complete and hand over, which is great. Um, the um, the it extends it to things that the seller themselves may not even be reasonably aware of, but a real estate professional will, right? That's why there's going to be some litigation here, unfortunately. Who will enforce? The DCA already appears understaffed and overwhelmed with Radburn, ADR, and reserves. So you're right, Bill. The DCA once regs are adopted, there are no regs that I know of right now, but once regs are adopted, I imagine the DCA will put something in the regs regarding enforcement. But I think, again, unfortunately, I think if the courts find that there's a private right of action under this statute, which I think they will, it will be enforced through private action, right? So you'll have lawsuits and management companies, real estate brokerages, and other professionals with dinged for failing to disclose or failure to provide information, and the practice will change just because of risk management. I mean, and again, as I said to Marsha earlier, I'm not in this field, but if I owned a real estate brokerage, I would be very concerned that all of my people disclose, right? Because I wouldn't want to catch the bullet for some seller who's like, yeah, don't tell them about the deck problem, right? That's the last thing you want. Same thing, people play games, and I've seen boards play games with this too. What is the real condition of the common property and how do you fund it? So there are associations that I've seen out there that will say artificially suppress their regular operating budget, right? So that when people are selling units, they can say, oh, the assessment here is $250 a month, right? But they don't tell people that year after year after year, they've been special assessing 1 or 2 times a year to basically fund reserves and operating shortfall. But they keep doing that because they don't want to tell the whole world, more or less, that the real monthly assessment should be $500 or $600, not $250, right? So there are all little details and nuances of this that I think can be problems for people. Seller property, Edna, seller property condition disclosure statements are already mandatory. Yeah, that's true. Yes, commissions have always been negotiable. I agree, Marcia. That's been my experience too. I've worked with a number of real estate professionals. I've never had a problem. They've always been professional, and it's worked out fine. The owner would have to deny access in writing, right? So, right, the owner, and this goes back to whether or not a potential buyer had to sign an agency agreement prior to entering the house. That's going to be kind of funky. The National Association of Realtors does not set commissions, says Marcia. It's mandatory now. So the problem was, Marcia, under the Bennett case, that it was the structure, the way it was structured. It wasn't specifying the actual dollars and cents of it. It was the structuring of again, the suit was brought by sellers, more or less, again, among other things, claiming that the sellers were forced to pay the buyer's agents commissions, right? That's number one. And number two, they were claiming that basically if you did not agree to that agreement, you would find yourself ineligible to be listed on the MLS, right? That was that was a second claim. And in addition to that, that even when there were fee sharing agreements, that, and again, these are claims of the plaintiff, that it incentivized buyers, realtors to steer the business, not to all homes, but to the homes where they got the best split. That was their claims under Bennett, right? So that's why it got funky. Is there a list of the items the DCA inspection can look at? And there is not. Oh, DCA inspection generally? Are we talking about 5-year inspections? Yeah, now Jeff's asking about 5-year inspections. Most are smoke and carbon monoxide detectors. I recently had one that cited painting in units, trees close to the building. I know they're self-funding, but this is so out of line from what I've experienced in the past. So Jeff, there are lists. I haven't looked at one recently. That's Jeff's talking about the 5-year inspection. This has nothing to do really. I shouldn't say nothing. This is a little bit tangential to today's discussion, but on a 5-year inspection, there is a list. I don't have one handy, but I'll see if I can get you one. Judy says you can control them to smoke detector only. So Judy, he's talking about the 5-year inspections. That's a little bit different. Yeah, exactly. That's right, Jeff. So I think we're clear. I know that was kind of fast. It might have been a little bit boring, and I think we're ahead of the curve on this because of the two Marcias out there. Right? Because so we had Marcia asking the question and asking the topic to be discussed, and we had Marcia on the line with us today providing helpful feedback. So that's a good thing. So hopefully this will ease into place pretty well without further messing up the somewhat messed up real estate market we have at the moment, right? So hopefully it will not mess up the sales and transactions in our communities. So it's a little funky now. Hopefully it doesn't get too funky. All right, but I hope everyone has a great weekend. As always, it's wonderful to see you, and I really appreciate you coming out today. We'll see you next month.